And they would just like to make a brief statement.
All right.
They are in full support of this settlement.
All right.
Okay. Good to hear.
All right, I've been handed a document indicating that Mr. Freed is going to be entering a plea to an amended count 1, which is an amended charge of criminally negligent homicide, a Class E felony. And pursuant to 40-35-313, he would be placed on 1 year's probation, and he would be required to attend the victim impact panel. And that all the other charges would be dismissed. Is that correct? All right. Mr. Freed, raise your right hand. Let's place you under oath.
Do you solemnly swear affirm the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you.
Would you, is this a guilty plea or a nolo contendere?
Guilty plea, Judge.
State your full name for the record.
David Allen Freeman.
Mr. Freed, you are here today on a 3-count indictment. You heard me go over what the agreement is that your lawyer has worked out with the state with the consent and agreement of the victim's family in this case. But have you seen or been shown a copy of those charges? Talk them over with Mr. Runyon. You and he discussed the range of punishment you're facing as well as any possible defenses you might have. Well, as indicated, move that microphone up so that, yeah, it'll be, there you go. You don't have to bend over, but it picks up better since we're recording. Do you understand that you have a right to plead not guilty and to have a speedy and public trial by jury in this court? You understand that if you went to trial, you would have the right to have a lawyer and have one appointed if you could not afford your own. You understand that if you went to trial, you would be presumed to be innocent until such time that ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you can be convicted of anything.
Yes, Your Honor.
You understand that if you went to trial, you and Mr. Runyon could confront and cross-examine every witness the state called to testify against you, and you can bring in your own witnesses by the use of a subpoena.
Yes, Your Honor.
You understand that if you went to trial, you would be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, Your Honor.
You understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, Your Honor.
You understand that by entering this plea of guilty, you're waiving your right to a trial and to an appeal. And all I'm going to do is approve what your lawyer has worked out with the state and with the consent of the family.
Yes, Your Honor.
You understand that under 40-35-313, you're going to be placed on probation for 1 year. If you successfully complete the terms of that probation, then after that year's probation is expired, you would have the right to come in and have your record expunged or wiped clean as though this had not happened. You understand that?
Yes.
You understand likewise that if you violate the terms of that probation, get convicted of some or get arrested for some new offense, or you violate the terms of the probation for any reason, then not only would this become a permanent conviction and be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime, but it would also mean that you could be brought back before the court and you could be resentenced to a greater amount of time in prison within the range of punishment that applies for that case. Do you understand all of that?
Yes, Your Honor.
Do you understand everything I've explained to you thus far?
Yes, Your
Do
Honor.
you want to plead guilty according to this agreement and waive your right to a trial and to an appeal?
I do, yes, Your Honor.
You understand that if you plead guilty, the court of the state could ask you questions about this offense, and if you answer those questions under oath on the record and in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if we determine that you are lying under oath.
Yes, Your Honor.
Is your decision to plead guilty today voluntary? Is anybody forcing you to do this against your will?
No, sir.
You understand I cannot accept your plea unless I'm satisfied that there is a factual basis for it and that you are in fact guilty.
Yes, sir.
Well, and that even though this is a guilty plea, you're going to give me a factual basis for it, you know?
I can, Your Honor. Your Honor, if this had gone to trial, the state would have put on proof that on August 29th of 2024, the defendant was driving with his friend Braxton James Madden here in Stewart County. They were driving a Miata. He misnegotiated a curve and the vehicle flipped, ejecting Mr. Madden. The reason for the plea, Your Honor, is at the time it was not initially investigated as a homicide. His blood did come back with some THC in it, but in talking to the experts, their testimony would have been that it hadn't reached his system yet. And There was no way to determine the speed of the vehicle because it's so old, it's the box. But based on the defendant's, some of the defendant's statements that he was going too fast for the curve. And with the family's blessing on it, that is the reason that we have come up with this.
All right, Mr. Freeman, do you understand that's what the state's evidence would be if this case went to trial?
Yes, sir.
You still plead guilty according to this agreement?
Yes, sir.
Are you satisfied with your attorney services?
Yes, sir.
Feel like Mr. Runyon has done a good job of representing you confidently?
I do, Your Honor.
Mr. Runyon, you know of any reason you should not enter this plea?
I do not, Judge.
If you will then have a seat here to the right, it's my understanding that the victim's family has a statement they want to make.
Well, just like to apologize to the court for my attire.
All right,
I wasn't aware of the short policy, but David, I want you to know, man, we don't hate you. Understand? So my son. And we drove him like we stole him and rode him till the wheels fell off, but me and my son always did that. We had this conversation, so I have on many occasions. Fortunately, I have friends. Just hope you take this and realize that I don't think anybody else would be as compassionate as we are. But what I talked to about is that we'll go to prison, take prison. We don't see any more choice in destroying any more lives in this whole ordeal, so carry this in your own self, it's your own prison. No, you are. Just want you to know that we're not mad. Trying to do the best thing of what our son would want. It's pretty much. Wouldn't want you to go to jail. I don't want you to go to jail. I know what jail does. And they're a lot. Get better criminals. Well, we left Arizona. But I just want you to know that we're not mad at you. What it is, but you guys went out to party drinking or it wasn't nothing like that. A young man going to go out and check out a restaurant. Hope you take the second chance at life, but you know, try to stop one other person from doing it. That's what life with loss. Let me know. Sorry.
Thanks. Wish I had that on video. Okay.
I don't see this very often in court where the victim's family in a case like this is so forgiving and compassionate that they are willing to not only agree to a disposition that a lot of people wouldn't agree to, but also have forgiven Mr. Freed for the taking of the life of their loved one. This is an opportunity for you, Mr. Freed, to basically have a clean slate after you've finished your probation. And you need to thank the Madden family because they're the ones who are giving you that opportunity. It would not happen without their consent. And obviously you have a close relationship with them. And I'm sorry that the circumstances are such that you have to be here today and that they have to be here today. But upon your plea of guilty to the charge of a criminally negligent homicide and amended count 1, counts 2 and 3 are dismissed. You're ordered to be sentenced, placed on probation for 1 year with the Department of Corrections under 4035-313. It's a requirement of your probation. You must attend the victim impact panel. You'll need to pay the court costs as well. So that's correct. Thank you. You need to see probation before we leave.
Thank you.
All right.
Judge, on page 8 of the docket, Michael Varner. You are 38. If I pass forward, he is currently in safe harbor. He's there today as we speak, or supposed to be anyway. It recently last week when I got an updated report. It's my understanding it's either a 9-month or a year-long program. He entered in December. If we set this for maybe August for a review,
All right, you want to set it in August, late in August? I can find it quicker than you can. So it would be August the 10th.
August 10. Thank you so much, Judge. Thanks for calling me. Thank you.